Buonasera a tutti, parlerò in inglese perché il mio inglese è più fluente che l'italiano. Good evening to everybody. Welcome at the Goethe-Institut here in Rome and everybody out there via Zoom. So we are some people here at the Goethe-Institut itself and many following at Zoom. I welcome you for the last series of this Europe special series of our green sofa. Well, actually, here's a green sofa and you are sitting on green chairs. So these are our hot green chairs tonight. So the title of tonight is Europe and the Ethical Question, from the Balkan War to the present day. And we welcome two very special guests, Flavia Lattanzi and Wolfgang Schomburg, both two former judges of the Criminal Tribunal for the former Yugoslavia and the Criminal Tribunal for Rwanda. And we are grateful, we are really very grateful that both of you accepted our invitation. And we are especially grateful to Wolfgang Schomburg, who made this traveling to Rome despite of these very special times and the travel restrictions. Thank you very much for coming. So today is the last evening of this series, and it's in collaboration with the Luis University, and I would like to thank really to Francesco Cherubini and his team, who has collaborated in an excellent way to conceive and to organize this event. And I would also like to thank the students. I see one here in the room and probably many out there at Zoom. For you students, tonight is a very special night because after tonight, and after the work we collect, we will announce the winner of a German language school, German language course in Germany, and two more language courses here at the Goethe-Institut in Rome. So I would also like to thank dear Michael Braun. It is really a great pleasure that you are the moderator of all the three panels. So today somehow you can conclude what we have discussed during the last three events. I would also like to thank my colleagues, Antonella Perin, Carmen Hoff, who have conceived and organized the series. And with this, without further ado, I would like to pass this microphone to Francesco, who will introduce you to our guests tonight. Thank you. Please.
Good evening and welcome. Thank you very much for being here, either physically or elsewhere, connected via Zoom. Before I briefly introduce our guests, who I'd like to thank immediately for being with us, let me thank the Goethe-Institut for all of the commitment and passion in organizing these Divani Verde debates, these green sofa debates, which aren't even easy given the times we're living. But ultimately, with a certain degree of stubbornness, we were able to conclude the series, and even, as the director was saying, to give these awards to the students who were with us throughout this process. Beginning on my right-hand side with Professor Flavia Lattanzi, who taught international law for a long time at the University of Rome, Roma III, and at Lewis University, which is where I met her. So I'm especially pleased to have her here, since she was my international law thesis supervisor many years ago. And it was at that time, if I remember correctly, that she was appointed ad litem judge for the International Criminal Tribunal for Rwanda, and then for the International Criminal Tribunal for the former Yugoslavia. After that, she came back to Italy, where she continued teaching international law. also at Roma Tre University and then at Lewis University, where I met her once again. Wolfgang Schönberg has a slightly different background, although his path crossed the one of his illustrious colleague. Wolfgang Schönberg began as a judge, I believe, and then between 2001 and 2008, if I remember correctly, he was appointed judge on the International Criminal Tribunal for the former Yugoslavia and then for Rwanda. And then a few years later, he also taught at the University of Dama at the School of Law, and he now continues to disseminate his knowledge, especially as far as international criminal law is concerned, which he continues to share his knowledge on in conferences such as this. Thank you once again. I'd like to give the floor to Michael Braun, who has accompanied us during these meetings, because he was the one who presented them all. This is the final meeting we're having, and therefore I'd like to give you the floor now, and I'm very eager to listen to our discussion tonight. Thank you. Now, if we go back 30 years, back to 1990, for Germany, it was certainly a very happy year. It was the year in which Germany was reunited. It was the year in which a development of events which happened very quickly reached its culmination. These were events characterized by the fact that they happened in peace, and not a single shot was fired in Germany, either before or after the fall of the wall, and no shots were fired during the whole reunification process. It was an entirely peaceful development. And this could also be said for the rest of Europe, or for most of Europe. Even the reunification of Europe, once the Iron Curtain fell, happened in a peaceful way. There were no armed uprisings, there was no armed repression, such as what happened in Beijing and Tiananmen Square, with hundreds, if not thousands, of victims. All of this was something that Europe avoided. But this major event, the reunification of Germany and the reunification of Europe, also had a corner of a continent in which very different things happened. Division, conflict, victims, wars. I'm referring to the former Yugoslavia. And from then on, for 10 years, as we only found out in details later, we discovered that there were terrible crimes happening in that part of Europe. Crimes that we will be referring to. In the 1990s, in 1994, in fact, we had a true genocide in Rwanda, with up to 1 million victims. And that also happened in the 1990s, which were happy years for us, as I mentioned earlier, although they weren't happy for everybody, not in the world and not even in Europe. And then these tribunals were set up as a reaction to the events in Rwanda and in the former Yugoslavia. These international tribunals had the duty of bringing war criminals to trial, not just the main leaders. Many remember the International Criminal Tribunal for the former Yugoslavia for Karadzic or Milosevic, but few are aware of the fact that there were many more trials And as already underlined by those who took the floor before me, we have two judges here who experienced those events in person. So let me begin by your experience. We'd like to know from you, what was your job about specifically between the Tribunal for the former Yugoslavia and Rwanda? And let me begin by Professor Lattanzi. You have the floor, madam. Well, I began working for those ad hoc tribunals created by the UN Security Council following my experience as a professor of international law, because no previous experience in the field of the judiciary was necessary. Although in the International Criminal Tribunal, bylaws foresee that even professors of international law can be appointed. I was an ad vitam judge, so I was only a judge of first instance, whereas Wolfgang Schönberg was a permanent judge, and therefore he was a judge of the first instance formally, and then he was a judge during the appeals later. My experience, both in the Tribunal for Rwanda and in the Tribunal for the former Yugoslavia, professionally speaking and culturally speaking, was very interesting. Both experiences were. There were also both very difficult experiences, especially in the Tribunal for the former Yugoslavia, because I worked especially but not exclusively on a fairly dramatic case, the Šešelj case. He was the chairman of the Serbian Radical Party. He was also a university professor. I'd like to underline that. He was a young university professor. He was a very intelligent man, and he defended himself both substantially and procedurally very well. But he was a Chetnik, so you can imagine what his ideological background was. I was also fairly unlucky because I was working with colleagues who weren't very accurate. This is something I wrote in the past, and I have no problems repeating this. I had some problems with the presiding judge, especially. And then we reached the end with plenty of difficulties. There were some significant delays. I think it makes no sense to continue to mention these details, but the person being tried was found not guilty, and I dissented with that opinion. This was a very interesting case, as I mentioned, and it was also a new type of case in terms of the offenses being tried, because Šešelj was being accused because of his hate speech. He was accused of having incited and instigated through the volunteer corps that he had created, in which he trained very well with his speeches and with his writings, and then he would send them out to the field to commit war crimes and crimes against humanity. It was also a very difficult case from this point of view. It was a difficult case given the types of judges
present. It was also difficult because of Šešel's behavior. Just to give you an example, as a way of describing this person's personality. He would disseminate hate towards Croats and Muslims. And at one point, there was a problem during a hearing with an interpreter who was Croatian. And he was very upset by the accent, by the Croatian accent. There isn't a great deal of difference between a Croatian or a Serbian accent. It's similar to what you would hear when in a southern Italian compared to a northern Italian. Of course, there are some differences. But this interpreter had translated the word pagan as pagan, and he was upset by that. He was terribly upset. He said, you're a Croat and you don't even know what pagan means. I didn't say that Muslims are pagans. What I said was that Muslims are excrements. That's just a way of explaining who this person was. He was then found guilty during the appeal. And with reference to the Šešel affair, I also like mentioning another instance which hurt me. At one point, he had been in prison for 11 years. It was preventive detention, and this thing was no longer manageable. It was entirely irrational. 11 years in preventive detention. So at a certain point, with the dissent of one of the judges, we allowed him to exit prison. The European Parliament intervened on insistence of the Croatian MPs, and they asked us to change our decision, to repeal this decision. This was a very serious thing in terms of the independence of the international criminal tribunals. This is something which never should have happened. And Madame Mogherini reacted fairly harshly following this resolution on the European Parliament's part. This Šešel experience also gave me the opportunity to use the case law of the European Court of Human Rights. And all of the case law was something I was able to use during when I expressed my view as a dissident to judge on the relationship between hate and freedom of expression. And the case law available, differently from what is often said, in other words, that the European Court for Human Rights gives absolute prevalence to the freedom of expression, is absolutely untrue. In fact, it does feel that hate speech is a boundary to the freedom of expression, and that's something I myself tried to prove. And having said that, let me just mention the fact that during the appeal, there was an old judge on the tribunal who was the president of the tribunal for many years. And up to last year, if I remember correctly, he was the president of the residual mechanism, which is the heir of the two ad hoc tribunals. Miron, an Israeli or American judge. And this person had expressed his dissidence during an appeal at the tribunal for Rwanda, and he supported the absolute priority to be given to the freedom of expression, therefore denying that hate speech could be criminalized. This same judge, Meron, as president of the appeal trial during the Shishel affair, then found him guilty of hate speech. And the significant thing to mention is that Shishel was found guilty for his actions in Vukovar with his Chetniks, and for his actions in Rekov Sea with his Chetniks. This is another town in which the majority of the inhabitants were Croats. And Shishel was found guilty, and I want to underline this, not just because he instigated the crimes with his hate speech, but also because of the hate speech per se. Much like the criminal tribunal for Rwanda had said, in which Mason had been dissident, hate speech is an evil per se, because even if it doesn't instigate specifically, the point is that it ends up causing certain offenses or certain crimes. And therefore, despite everything, despite the difficulties, despite my relationship with my colleagues, then once one of the two colleagues was replaced, I had no problems with the other colleague, although he did end up causing problems with some remarks he made to the press. In fact, it was an email that then ended up in the press, and therefore this judge had to leave the tribunal. And he was unfortunately replaced by a judge who felt that the crimes were simply the result of things which had happened due to an ideology, that of Greater Serbia, which is a political ideology, and therefore Shishel was not responsible. Now, when acquitting Shishel, my two colleagues also managed to say that the expulsion and the deportation of women and children who were forced to leave on buses which had been organized by Shishel and by the Serbian Bosnian leadership to send them away from the territory, which had to be cleansed of the Croat and Muslim ethnicities. Well, in the ruling, what they said was, and this caused a scandal, that these buses were a form of humanitarian assistance to women and children. They weren't deportation. And the other experience that I like to refer to as a more general reference, and it refers to the somewhat controversial debate which happened between the judges who belonged to a common law background and those who belonged to a civil law background. In another trial, in another affair, not the Shishel one, this referred to the chief of cabinet of the Bosnian Muslim army. The judge who was presiding the court managed to say during a hearing he was referring to a procedural issue. He said, well, here in my jurisdiction, we apply common law. We have other rules. And I had to react, and I said, well, we're not in your jurisdiction here. We are in an international criminal tribunal, which shows that this aspect did emerge sometimes, because the whole procedural, the procedures had been prepared by the U.S. State Department, although initially they were prepared by Italy and France, specifically, in Europe. And I'm referring to the tribunal for the former Yugoslavia. So this problem, at one point, the first president of the tribunal, Judge Cassese, who came from a civil law system, he tried to amend the procedural rules and the rules for evidence, giving a little bit more, or giving less importance to the hearing, which according to common law is the backbone of the trial, and he tried to give more importance to the evidence, the documents. That issue, the issue of evidence and documents, was something of a burden for me, because, for example, in the Scherschel case, in which there were some different underlying ideologies behind all of the behavior, all of the criminal behavior. And I felt that evidence should have had major importance. And I spent many nights going over the documents available, which of course had to be analyzed. They were translated into English, not into French, which was my working language at the tribunal, especially during the whole Scherschel case. But at the end of the day, all of these documents, all this evidence, wasn't given the importance which I felt that evidence required. And that is a flaw which I think continue to exist in the work of the international criminal tribunals. And it's especially important when those tribunals try even the material executors, and of course the real, the people who are really responsible, the leaders, the ringleaders, these higher echelons, all the way up to heads of state and government, naturally, or leaders in society, or chiefs of staff, who don't necessarily have a presence in the field, but of course who are responsible hierarchically. And in order to prove the responsibility of these leaders, well, I think that documents, that evidence are important, and I think they deserve greater relevance. Thank you, Professor. Before I give the floor to Professor Schomburg, just a quick question. What was the ruling for Scherschel? How many years was he sentenced to? He was sentenced to 10 years in jail. He had already been in prison for over 11. More than that, in fact, once he was sentenced. He was put on probation, but he had already been sentenced for his hate speech. Thank you. Professor Schomburg.
Professor Schomburg,
I'd like to give you the floor immediately,
le do subito la parola così
so you can tell us a little bit about your experience.
La sua esperienza. Mi ha accennato anche magari
and perhaps you can also say a few words about
non c'è.
Can you hear the translation?
Don't they translate it?
Yeah, okay.
Yeah.
It's
Yeah.
rather difficult, but
Yeah, okay, no, then I say it in English. What we now would like to hear your experience, and maybe also in the end you told me before about how we arrived, how important the work of some professor and his students was to arrive to that court. Maybe you would be so kind to add that too. But first off, your experience.
yeah, thank you. Something seems to be wrong. So, first, to apologies of mine that I can't speak Italian. I've tried, but I have heard that here in this house. No, it's okay. Okay. That in this house there is no course for Germans that want to learn Italian, which I was always eager, but I never managed. Second, that I come back a little bit to history. Why this? Because today, with a view to the age of the people present here, I'm afraid that many, and I have heard this from my students, take it as granted that there is something like an international tribunal. Please be aware that there was a heavy fight since 1872. The International Committee of the Red Cross fought for an international criminal court, that the rules and the law of warfare in particular is not only in the books, but it's realized, it's applied. At that time, the fundamental rule was when there is waging war and you hear the guns and grenades, then the law remains silent. And it was always the attempt to overcome this approach. We had this attempt for the first time in the Treaty of Versailles, where the Kaiser and 3,000 Germans should be prosecuted. We all know nothing seriously happened. But then we had Nuremberg and Tokyo after World War II, the first real international tribunals. Some people say it was flawed because it was established by the winning powers. True, but having a look in particular to the judgments in Nuremberg and the jurisprudence of Nuremberg, one must say that this was a fair trial and they did their very best to come to just solutions. And having mentioned Nuremberg and Tokyo, if you once should read judgment from ICTY or ICTR, you find references to judgments of Nuremberg in particular, but also from Tokyo,
rispettivamente i tribunali internazionali.
This serving as a guideline for a brand new tribunal established for the first time in 1993. Since 1983, I had the pleasure and the honor to work together with the late Professor Sheriff in the Institute in Syracuse. And there we tried to work out to establish a draft for an international permanent court. But
È saltato il microfono del professor Schomburg.
the war in very courageous man, and not only an excellent lawyer, but also a practitioner. He took many of his students to prominent Israel. They went to the areas of war and established the fact that there were incredible high numbers of mass graves. And they dared to exhumate these corpses against the wish and the will of the major powers. They wanted to stop him. They didn't even, when corpses were exhumated, willing to sell the sacks for the corpses. So it was a fierce fight, but he managed, and it should not be forgotten that at the same time, more on a legal basis, but also factual, Hannah Greve from Norway added fundamental opinion. They presented this evidence to the Security Council of the United Nations. And based on this, the Security Council could not but establish the International Criminal Tribunal for the former Yugoslavia. Why the reference to this? Because it's for you, the younger generation, not simply to wait that something is done, but to take action together with others in a responsible way, that also in the future there will be an international tribunal present. There is no doubt an international tribunal. And major nations, they don't want to have it at all. But it happened at that time, and apparently, to make a little bit a mean remark, apparently the veto powers in the Security Council, they thought it will never work, and therefore we should not be afraid. And thus, based on the UN Charter, Chapter 7, Article 15, they took action, I quote, action with respect to threats to the peace, breaches of the peace, and acts of aggression. In the past, it has always been a military intervention. And now it's a minor invasive measure to try to bring the responsible persons to justice in a civilized way. In the very beginning, it seemed that the representatives of the major powers were right, nothing happened, and I would say only as of 1999, following then after the elections 2001, it was a real work, and I can tell you it was really a lot of work, too much work, because out of the blue we got many evidence presented by groups of victims, and reliable evidence from the first ever case that was a case against a minor person, Tadic, that later, in the years later, would have been never been subject to a hearing before the ICTY. And but based on this, on the factual findings in Tadic, numerous cases started, and immediately it seemed to be too many cases, and we, the judges, permanent judges in the plenary, we came to the conclusion that we can only focus on the main suspects allegedly having committed the most serious crimes. And it was a number of 160 cases, and all cases were concluded, apart from the two ones still pending, but we have addressed all of them were indicted and acquitted or found guilty. It was extremely difficult. And then later on, based on the wish and the will of Rwanda, the Security Council had a similar statute as a basis for the work in Rwanda. We had the court in Arusha in Tanzania. It was interesting to compare the work of both, but to begin with, when I was asked to become a judge of this tribunal, are you prepared? I said, why not? I have worked since 1983 on this idea. Finally, after a long and winding procedure, you must imagine it's for the candidates to come to New York and to present themselves. I'm the best judge. Without me, it will never work. And yeah, you had brochures from other colleagues, 20, 30 pages long, showing them together with the family, together with the dog, and so on. But the problem was many of them were, to be very direct, not qualified at all to act as a judge. So it was Kofi Annan who appealed to the plenary that please elect qualified judges or qualified professors of law, having shown that they are willing and able to deal with these cases. After the election of 2001, it was true, and we could really start, but you can imagine it's difficult when you have to work with colleagues, having seen a courtroom from the inside, maybe only for kind of parking offense they have committed, and otherwise having heard nothing about criminal law. Arriving in The Hague was more or less shock. I wanted to have, of course, as a judge in continental Europe, I wanted to have my file, that I can prepare myself, that I can see where are the strongnesses, where are the weaknesses of the case, what questions to put to a witness and to on. But I was told, you don't have file. It's a party-driven system. The prosecution will present their own evidence. Having concluded, you have to decide whether they made a case or there is no case to answer. And afterwards, if there is a case to answer, and insofar there is a case to answer because we limited some in parts of the indictment, where in our opinion, the prosecutor had not brought the necessary evidence. And then the defense presented their own evidence, and then we should conclude, so that we should act without knowledge. And of course, it was necessary, in particular for me, having worked both as a trier of fact in Berlin and judge of last instance in Karlsruhe, in Germany. for me, it was necessary that I can follow the thoughts and have access to all the evidence. And we were never allowed to have access to all the evidence. They were in databases, but we were not allowed to access these databases. So it had to be developed that step by step, the judges played a more intervening role and more active role. To give you only also one example, it's always difficult to hear, yes, here common law and there civil law. I found it from the very beginning outrageous that the prosecution presented witnesses. They had already undergone a treatment of 3 to 5 days in a kind of trying the case beforehand. If the judge or if the other party puts a question to you, what will be your answer? That's not right. You have to answer the following. That is a kind of, really party-driven evidence, and addition, the coaching of the witnesses. Fortunately, it was later forbidden in the International Criminal Tribunal, and we invited and urged the prosecution, and also defense, of course, to stop with this American way of preparing a court in a way that, and I had often to tell people, please stop to play a theater. It's not a theater. We are all professional judges, and you need not play this, what you would play in the United States before a jury. And it has one additional disadvantage. Defense counsel from former Yugoslavia, they could not appear alone because they were not acquainted with the common law system, and they always had to be accompanied by a defense counsel colleague from one of the Five Eyes. To be mean again, we'll say United Kingdom, United States, and Australia in particular. So we started there, and I think it has already here to be mentioned that when a reference to the order we have received, that we have to take care of the peace in the area, that we were more or less all driven by the fundamental ideas of all religions of the world. To give or two examples, in the Talmud, you will read that the world rests on pillars, on truth, on justice and peace. Or from Paul VI, if you want peace, work for justice. And this was combined by us, the judges, that there will be no peace without justice, no justice without truth. And there we had the truth-finding mission. But on purpose, I mentioned the way we received the truth, the alleged truth, part of the truth by the prosecution, by the defense, but we couldn't fulfill this mandate to find the full truth based on the available evidence. And it has to be emphasized that It is a question of available evidence. Don't think that, for example, in certain cases I have in mind, when we knew that, say, intelligence of United Kingdom or in particular United States was available, they granted us access to this. But I shouldn't blame these two countries. It was also the European Union. We, as the three judges, as triers of fact, we came to the conclusion that we needed, in a concrete case, certain documents we knew that they were in the archives of the European Union. I asked colleagues to contact with no result. I took the phone myself and contacted the leader of this archive. And he said, yeah, but you are a lawyer. You must know in the European Union, we work based on unanimity. We have these documents, right? But we will not disclose it to you before you give us the written permission of 27 member states of the European Union. It's a mission impossible, but it's the way countries step by step approached this tribunal. Cooperation could have been better, in short. But what was far more important is that we finally managed to do this work, to bring it to an end. And I would say, apart from that, it was, for example, said by Flavia Latenzi, and in parentheses, I had the pleasure to introduce Mr. Seychelles to the ICTY. I was a judge for his guilty plea. And I will never forget this, because I never, as a judge, prosecutor, or defense counsel, was that humiliated in the way as in this first audience of Mr. Seychelles, because interestingly enough, he insisted in front of Carla de Ponte, the at that time prosecutor, to be brought immediately to The Hague and to be indicted immediately. A big question mark still for historians. Why was it? Because 40 days later, the indigent president of this area was murdered. And will you ever find a better alibi than being in The Hague in prison? But fortunately, we have this idea of the perpetrator working behind the scenes, but it has never been established until today. But I had it in mind. But when I entered the courtroom, together with my colleagues, he wanted immediately my disqualification, and also the disqualification of my colleague, Judge Mumba in Zambia. Why? Because Judge Mumba, she appeared, as he said, in red robes, like the Vatican robes, and they are nothing but an assistance of the Vatican. And to me, he told, whenever a German judge enters the courtroom, he smells the taste of the concentration camp in Sachsenhausen. Normally, I could have overcome this without problems, but he, I hope, didn't know that my grandfather was killed in 1948 by Russians in the concentration camp of Sachsenhausen. And this man dares to say that I have the smell of a person coming from the concentration camp, only to see how it impacts us, the judges, how it works. But generally speaking, I must say, I was very impressed what a civilized way the majority of cases were heard indeed. And it was in this context, it's difficult to speak about pleasure, but it was a real pleasure to hear when a witness, in particular women, raped. And unfortunately, we have at the end of the day come to the conclusion that rape has become also here, Rwanda and former Yugoslavia, a mean of warfare, to humiliate other people, to destroy them, to make them to nothing. But that they were courageous enough to come to The Hague, to testify, and then afterwards, either by letter or later in meetings with victim organization, to express the gratitude that they had the opportunity to address the court and to be confronted with the perpetrator. And it was really one experience of a lifetime to see that most of the perpetrators, they avoided eye contact. They were really shy. They didn't want to see the victims again. And this is the main point. At the time when they committed the crimes, they never believed that there would be ever a court dealing with this case and bringing the perpetrator to justice. I think that is the most important achievement of these tribunals. And in general terms, it shows if there is a political will to establish such a court and to grant cooperation and to grant independence to the court, then it is possible to adjudicate also the most serious cases. And in today's world, you will ask, no doubt, why don't we have a case hearing on what happened in Yemen, what happened in Syria? It's scandalous that we don't have such a court, that we are always blocked by the veto powers, in particular, in this case, Russia, but don't put the blame too much on Russia. Also, the United States tend to veto these important issues, and they have far more, they exercised more vetoes than Russia. It doesn't help at all to put the blame on the one or other, but we have to find ways to establish also in the future tribunals for these other areas, so that justice can be seen to be done, and that the idea of International Criminal Tribunal survives against all odds, and I hope it will. But all of you listening here in this room or via streamlining Zoom, work for this, as it was said by Pope Paul VI. If you want peace, work for justice. If I may, I want to conclude now. Maybe I have the chance to come back later about the unfortunate political interventions in our work. Thank you.
Grazie, Professor Schomburg. Thank you so much. Indeed, this was the point which I wished to touch in this second round. We must be a bit shorter than in the first round, but you gave us a very plastic image of those international courts, above all ex-Yugoslavia, but you also touched Rwanda. You talked about independence. Indeed, it seems, being an international court established by the UN, that it is independent by itself. It doesn't depend on a single state. No single state, one thinks, could easily interfere. Is it that way? Have there been no interferences, Professor Lattanzi?
No interference on any state's part, not even mine. I just received a letter with threats to the president of the tribunal. Unfortunately, I received a letter from a diplomat, or a letter from a former diplomat, from a former Italian diplomat, together with a letter from the vice president of the Serbian parliament, who belonged to Mr. Šešel's party. So I received a letter with threats, and I handed it over to the president of the tribunal, but I never had any interference from any state.
If Professor Lattanzi tells us that she hasn't had interferences, can you say the same? No attempts to interfere with the court, with you, with other colleagues? Professor Schomburg.
I can't come to the same conclusion. I don't want to refer to rumors of intervention because they happen not normally, not on the level of the judges, but on the level of prosecutors. That prosecutors should bring certain cases and leave it to bring other cases. In most cases for political reasons. And I have two concrete examples in mind where I really saw the intervention. The first, to put it very short, is simply to note that never a French person was charged with crimes which would be under ordinary circumstances. I was a former prosecutor myself, and I would have brought charges against those responsible for selling some million of taketes to Rwanda at the time when it was already known that the 6th of April 1994 the genocide would start. And you see in the memorial in Kigali today a list of all those French companies having sold these maquettes to Rwanda, and all these contracts guaranteed by the French government. The maquettes were distributed in the entire area of Rwanda by French soldiers, and all these two acts, they would already, in my mind, amount to aiding and abetting to the crimes when it is about genocide, aiding and abetting genocide. If the person knows I bring a weapon or thousands of weapons to the perpetrator, then in ordinary life, it's aiding and abetting to genocide. And I think this is one point that's really missing. Because the selling, first the production of the selling of these weapons, that's always the basis of that what we want to avoid, war. And therefore I would have appreciated that already for these two reasons there would have been indictment. But also from certain cases we had to hear from witnesses that they were trained by French judges, that when there was a borderline, a checkpoint, that it were French judges standing there and saying either thumbs up, you may go ahead, or thumbs down, go to the other side, which meant that they would be killed. And also evidence, ample evidence, that they were trained that they should not cast the corpses and the bodies immediately in the water. Why? Because the rivers would turn red, and this could immediately be seen by satellites. I think this is also one approach, and I learned from prosecutors from the ICTR that it was primarily, of course, France, but also the United States not allowing access to the compelling evidence they had for this. Okay, but the most serious intervention I must mention, because it came from here, not from Rome, but from the Vatican. We had a serious case, the priest Seromba. He must have known already from the very beginning, 6 April 1994, because already on the 8th of April 1994, he opened the doors of his church and invited Tutsi victims to enter the church because he wanted to grant church asylum. And when the church finally was packed, the numbers differ between 3 and 2,000. As a judge, you have to say in doubt in favor of the accused. We came to the calculation 2,000 people were inside. He closed the door, asked the attendance of major or dominant people in this small town. And then a bulldozer driver was asked to bring down the church. And it took about 1 day that this bulldozer driver drove over the church, and of course, all the human beings inside the church. If you compare it with other wars, you will see like rape. Also, this is, I don't know why, an act of warfare to be found in several places. But here we came to the conclusion and the finding in the judgment, you can read it there, that it was a priest standing there and insisting that the driver continued and continued and continued, because he always said there is still some movement, you have to go over this. And it was really shocking on appeal to hear the evidence on this bulldozer driver and to know about this. And then the history of the fate of this priest was that he was brought to Italy. He acted as a priest in Firenze. We were happy that we had a Italian registrar at that time, and she managed to bring Siromba back to Arusha. I started to become involved in the case on appeal. We heard the case, the appeal, and the first instance had decided that in this case, 2,000 victims, 14 years of imprisonment were enough. We concluded, no, it's a clear-cut case where life imprisonment is mandatory. And after the hearing, we were approached by Judge Hokar, at that time president of the appeals chamber, and Judge Mösen, the president of the Rwanda tribunal, and they both told us that they were approached by representatives of the Vatican, that we, and in how far we could put the entire case under the carpet and not hear this case at all. I think it's incredible, but I'm grateful to both presidents that only on this level they told us about this intervention, because we were able to decide the case without any impact on this information from outside. The intervention of a certain country, here the Vatican, the final highlight was that after the judgment that had normally to be served in Mali, out of the blue, Italy offered that the judgment could be served in Italy. And fortunately enough, the then president decided no way after that what we have seen in the past. And if I know it correctly, he is still now in prison in Mali. But it's only one example, but a serious example, what is possible on this level. And this should never happen. We need the active, positive cooperation with countries. In my mind, to my mind, international tribunals, that's the highest form of international cooperation in criminal matters, in that countries bring together judges from their country, and they decide, hopefully in an independent way, on these concrete cases. And until today, on the basis of our work, both in Arusha and in The Hague, in both countries, the judiciary is working. And also, to give you my personal opinion, I'm deeply impressed by the work done at present of our judges, the colleagues in Rwanda. They are excellent, and they are far more efficient than our judges in Yugoslavia. I don't want to comment on this observation, but it is an opinion. I could give some reasons, but it's not the time to do it today.
Okay.
Thank you.
Thank you, Professor Schomburg.
If I may just add something very briefly, following what Judge Schomburg said. First of all, regarding interference by the Vatican, and I'm not saying this because I'm Catholic, I'm not in fact, but I did want to mention that Shibumba reached Arusha thanks to the Vatican, because Italy still hadn't passed the law to adapt to the statutes of the tribunal, and therefore Italy wasn't capable of arresting him and handing him over to the tribunal. Italy couldn't cooperate in handing him over to the tribunal for Rwanda. Due to our attitude, which was somewhat racist, because we immediately adapted to the statute for the Tribunal for Yugoslavia, whereas it took us a few years to adapt to the statute for the Tribunal in Rwanda. Well, we were thinking, well, it's so far away, we can ignore it. Now, he was hiding in a parish, and he was discovered by an NGO. Again, he was hiding in a parish in Tuscany, and at that point, since Italy had this obstacle in terms of handing him over, in terms of arresting him and handing him over, the Vatican convinced him. They paid for his airline ticket and sent him to Arusha, saying, well, if you are innocent as you claim to be, prove you are. So this interference did happen. And perhaps the person who dealt with this case then changed. As far as the other aspect is concerned, I fully agree with Mr. Schenberg on the topic of the policies or the political choices made by the prosecutor. It's true. And I myself saw it in the case of Mr. Elic, who was the chief of staff of the Bosnian Muslim army. And then, from what I got to know regarding the case, I was in the judge's chamber, and I discovered that there were some things that he could have been accused of by the prosecutor, whereas the only thing he was accused of was the lack of prevention and the lack of repression of the crimes committed by the Mujahideen. And he used to travel around Arab countries to recruit these Mujahideen, and in fact he created a Mujahideen battalion. In fact, he did something more than that. And basically, judges have to simply analyze what prosecutors give them. They can't add anything else. This was a political choice by the prosecutor. So, from that point of view, I fully agree. But let me add that I sometimes had the feeling that some judges, that some colleagues of mine, it's not that they were approached by their countries, but it's almost as if they were behaving in a very zealous way so that they could please so that they could please their governments, basically, so that they could meet their government's desires. That's a feeling that I sometimes had in certain cases. Thank you. We're heading towards our conclusion. I would kindly ask you to give us your point of view. Now, we discussed the fact that they were able to see how important these two international tribunals' experiences were. But it's, are we lacking a permanent tribunal? And you also mentioned the forces which oppose such a tribunal, namely Russia and the US. What could Europe do to bring this idea forward, to support this idea? Well, first of all, we do have a permanent tribunal. We have the International Criminal Court, which is also based in The Hague. The problem is that the competencies of the International Criminal Court have to be accepted by the various states, either on a territorial basis or on the personal or active criterion, referring to the nationality of the perpetrator or of the offender. Therefore, the cases that Mr. Schoenberg mentioned, the one regarding Syria, for instance, the problem there is that there is no competence on the International Criminal Court's part. Although it is a fact that the Security Council did create these two international tribunals for those emergencies in the former Yugoslavia and Rwanda. They did create these two ad hoc tribunals. They could have done the same for Syria. The problem is that they didn't. There were some proposals, but things didn't move forward, given the fact that some states vetoed that decision within the Security Council. So the limit of the International Criminal Court is the one I mentioned, the fact that they don't accept competence. This doesn't mean that the International Criminal Court isn't doing anything. Currently, in fact, they're working very well in investigating crimes in Libya. And there is also a certain degree of cooperation with the Italian jurisdiction, given the fact that Italy knows a lot about what happens in Libya, given the flows of migration across the Mediterranean. Many migrants reach Italy with scars, with psychological issues which are very serious, following the way they were treated in Libya. And that's something that is being dealt with. As a conclusion, let me just mention Europe. Europe has made some mistakes in dealing with the Balkans, in dealing with the conflicts in the Balkans. First of all, because it acted late in proposing the peace plans. The first peace plan was interesting, whereas the other two simply accepted the ethnic cleansing which was happening in the field, and it was only fair that they weren't accepted. Not by the Serbs and not by the Muslims, because the Muslims claimed that the Serbs had obtained too much from these peace plans. So Europe could have done more. The United Nations also could have done more. Instead of intervening with the embargo on the sale of weapons or economic sanctions throughout the territory of the former Yugoslavia. And in fact, I remember what the Romanian Jewish writer and philosopher, Mr. Riesel, said. He said that neutrality benefits the torturer, not the victim. He said silence benefits the torturer and not the victim. And sometimes we should not be neutral. We must intervene. The possibility of armed intervention had been discussed early on, and then nothing happened. And then time went by, and I think that among the mistakes which were made, one of the mistakes was that we would simply look at the events happening in the field. Initially it was the GNA, and then everything was handed over to the Serbian Bosnian army. And it was one of the best armies in the world. It was very well equipped. It was a strong army with a great deal of discipline. So honestly, neutrality, even with the weapons embargo, was simply something which ended up being an advantage, or a great advantage for the ethnic cleansing which happened. And it was perpetrated by all three ethnicities. But it did benefit the ethnic cleansing carried out by the Serbs for the most part. They were able to do what they did because they had the military strength to do so. And it was essential, and it worked also because of the neutrality which surrounded that conflict.
Professor Schomburg.
Yes, I also want to approach on the two levels, global level and European level. On the international level, hope can be seen in the fact that there is already a fact-finding mission in place in relation to Syria and Myanmar. So they can prepare a case, and they always can come with indictments, and they are ready for this. What they are doing there, more or less silently in Geneva, it's really admirable. These are the former cooperators in the international tribunals for Rwanda and former Yugoslavia. The question is, how long will the international community tolerate that we are simply looking away and committing ourselves on ethical misbehavior, and that we tolerate that there is no court for these areas and other cases, and that on the one hand the General Assembly has sent a case also on the will of the veto powers in relation to Sudan to the Permanent International Tribunal. But what does it help if the international community is not willing to cooperate and to arrest Mr. Bashir? He's wanted since 10 years. He's seen here, there, and everywhere. And all the member states of the Assembly of the ICC, they simply let him go. At present, he is arrested for another crime. But I had hoped that in the past, he would have been brought to justice. Because if you empower a court, then you have also to give the necessary cooperation to this tribunal, and also this aspect should be mentioned, try to humiliate the prosecutor and a member of the prosecutor's office of the permanent ICC, as it happens at present by the United States. I don't want to qualify it legally, but to freeze the assets of the prosecutor of the ICC and to not allow her to come as usual to New York is something outrageous. And I hope at least this approach will change after the next election. But your question was, and coming back to the topic of this 3 table rounds you have guided. In hindsight, I would have said, wouldn't it have been better that the cases dealing with former Yugoslavia could have been heard by a European criminal court? Isn't it a European question? We have seen that Africa is starting with an international criminal court. And I think it's a good development. Why? To put it very short, I felt uncomfortable as a European judge to act in Africa. I didn't understand the body language. I had a problem with the translations from the language of Rwanda, Swahili, French, and then finally at my ears I could hear English. We all know that we make generally 5% of our work in a wrong way. So what has it to do with the reality we hear there? And do we know enough about the background and of that what happens in the area? On the other hand, I have seen judges from other continents working in the ICTY from Yugoslavia, and they ask, or they put extremely strange for me questions about Yugoslavia and what's the meaning of waging war in Yugoslavia. They didn't know about the start of the World War I, and they themselves, at times, they were honest enough to say, I didn't understand. Whereas I, as a trier of fact in Germany, was acquainted to treat alleged offenders in courtroom because they have a certain, at times, aggressive way to address the court. And I would know how to handle them in a far better way. Wasn't it a European problem? So, but unfortunately, EU has said, no, we don't want to have a European criminal court. Despite they have said this, they have established court related to Kosovo, allegedly requested by Kosovo that EU assist Kosovo by having a court on crimes committed in Kosovo since 1999, and it has started. And my first question is, why couldn't ICTY have continued with this, having some knowledge about victims and witnesses in the Kosovo and how difficult it is to deal with these cases, but they could have used their own experience. In spite of this, a new tribunal was established. And again, interestingly enough, United States insisted that they bring the prosecutor, and only an American prosecutor, during the time there was a vacancy in the office of the prosecutor, and there was a substitute, I think it was from India. He was not allowed to bring an indictment. He had to stop and to wait until a US prosecutor would come. Also, this shows kind of political influence, to put it mildly. I think the international community today would expect other areas, I mentioned already, Myanmar, Yemen, Syria, instead of minor crimes committed on the territory of former Yugoslavia, but in Kosovo. There we, out of the blue, have a European Criminal Court, but only for this area. I don't know what is the legal basis. I have tried, but I didn't find any. But it is there. I would hope that a Europe, a core Europe, a real democratic Europe without, say, Hungary, not respecting fundamental human rights, not respecting the independence of the judiciary, that such a core European Union would establish a European Criminal Court also to deal with these international crimes. Thank you.
Thank you, Professor Schomburg.
Professor Schomburg.
Just a very brief follow-up. I'm sorry, but I don't agree with Professor Schomburg on this aspect of the regional tribunals. First of all, what I notice is that Africa has decided to give itself a regional criminal tribunal simply because this tribunal will follow the things which are already stated in the Charter of the African Union, which is immunity for heads of state and government. So basically it's just a way of defending one another, of defending each other's heads of state and government. Al-Bashir wasn't caught because the African countries he went to, either on public or private visits, these African states didn't arrest him. Even South Africa allowed him to flee. They even gave him an airplane for him to flee on. So I wouldn't really trust these regional tribunals very much. I think that the meeting of different cultures from around the world is the best possible tool so that international criminal justice can be organized. And in fact, what we've learned from the tribunals for Yugoslavia and Rwanda is that sometimes we tend to insist a little too much on one's own legal background. I'll conclude by mentioning Kosovo. Technically, it wasn't possible for the ICTY to continue to deal with these other cases which emerged after its activities. And the Tribunal for Kosovo, in fact, was created because Serbia insisted. Kosovo wasn't really interested in it. Its parliament wasn't. And now we have these arrests happening. We had the arrest just 2 weeks ago, maybe 3 weeks ago, in fact. And there have been major protests in Kosovo. The truth is that the ICTY couldn't step in and deal with Kosovo because at one point the Security Council stopped it. No more accusations, that's what they said. And therefore they could only continue to deal with the 161 cases which were being discussed following the accusation. And then, and I can't remember the exact date when this Security Council resolution happened, following that date no further accusations could be made. The EU created that tribunal, and I think it's only fair because the ICTY, for instance, tried Radinaj, who was one of the leaders of the UCK, and they weren't able to do anything because there were intimidations and murders of witnesses, and ultimately the evidence just wasn't there. And now, basically, a relative of that Mr. Radinaj is also being tried by the Tribunal for Kosovo. So I fully oppose regional courts. I'm sorry I don't agree with you, because I usually tend to agree with him all the time. Just a very brief answer.
Brevissima replica.
Thank you for this permission. No, I want to say in the same way the Security Council, put it this way, stopped the ICTY in continuing with his work. It would have been easy for the Security Council to continue with this work. I have dealt with this with representatives of Germany in New York, and it would have been easy to give permission to continue by hearing this allegedly missing cases. But please let us recall that the court was misled by Carla de Ponte in that they spoke about the theft of human organs and so on, and extremely serious cases. But seeing now the indictments, there is nothing about this, and I wonder whether this will be a possibility. And when you say regional courts, that's not the best way. How else shall we deal in the future with similar situations? It's at present that nearly all, or the vast majority of European courts, the one or other, are hearing cases from Syria, for example. But it's an incredible effort for those courts to hear one single case, totally in abstracto, without access to other evidence heard by other courts. And we have seen examples that the Norwegian court came to a different conclusion opposed to a German court, simply because of different evidence adduced. So why shouldn't it be possible that Europe becomes also, as regards the judiciary, a strong global player? We all have seen and we all are aware how, for example, the United States, by their own judiciary, tries to extend the American judiciary throughout the world and to govern also legally the world. I think it would be a good way if Europe, in particular the EU, but we should not forget that there is still existing a Council of Europe that has done an extremely good work for legal cooperation since 1950, since the elaboration of the European Convention in all areas of criminal law and criminal procedural law. And why shouldn't we exercise this and apply this law in our homeland, in our European region, in a European Union we believe in?
Thank you, Professor Schomburg. And with this question you made at the end, and with this question in mind, I'd like to conclude this conference. Thank you for sharing so many ideas with us. Thank you for sharing a very detailed explanation of the activities of the tribunal and the problems they faced. So thank you very much. as far as I'm concerned, and I'm sure I'm speaking on behalf of the audience too, both those physically present and those who attended our conference via Zoom. Thank you very much indeed.